and everybody's against you.
I mean, this is someone's life, so I don't really care about it.
Okay? I would encourage you to listen to your fellow jurors, and if you
Sure.
change your mind, great, because your mind's changed, and it's then your verdict.
Right.
But I just want to make sure I've got folks that aren't going to be like, it's Friday night, or whatever, you know? Everybody promise to do that? All right, anybody have something you feel like you need to tell me? I didn't ask the right question, I didn't call on you. Something you think I should know about you that's related to the topics we've touched on? All right, thank you very much.
For the defense inquirers, we are going to take a brief break for about 10 minutes. You'll have an opportunity to stretch your legs, use the restroom, or look at your phones or devices if you need to. This break will be for everyone, but that is both in the box and also in the gallery. While you're on your break, you're not to speak to each other concerning this case or at all. Do not speak to anyone else concerning this case as well. We will resume with the jury selection at 1:30. You may use the restrooms and leave the courtroom at this time.
Can everyone here agree that 12 heads are better than one? Shake your head.
Yes.
Yes, okay. Now it's important right now for you to understand that. We're not trying to trick you. There are no right or wrong answers. We want to know what you believe. Now during this process, would it be wrong of me if I were to ask you for your each individual own worldview? You know, we all have our own biases, resentments, beliefs. And I need to know, and I'm going to ask you to share with me, whether or not you're going to carry that with you into the jury box. Now, there's a concept that has gained momentum recently, and that is the concept of implicit bias. Does anyone here know what that is? No? Okay. Well, I'm going to try to explain it briefly. Now, we all want to see ourselves as fair. Can we agree to that? Yes? Okay. We all want to believe that we're rational. Can we agree to that? Now, unfortunately, studies have shown that despite our best intentions, none of us are free from these biases. Implicit bias refers to unconsciously held beliefs that don't necessarily reflect our conscious belief. So, for example, you walked into the courtroom either Tuesday or Wednesday, and you saw a gentleman in a black robe. When we see someone like that, we can assume that they're a judge. And you made that decision pretty quickly. Is that correct? Okay. So what if you were to walk into a supermarket and there's a big burly guy with a long beard, clad in leather, and he's walking to a motorcycle? Let's see. Number 5. When you see that, do you see someone who's adventurous?
Yeah, I mean, I guess they're riding a motorcycle.
How about dangerous?
Not necessarily.
Okay. Now, you're making a quick judgment when you see someone like that, right?
Yeah, that's an implicit bias, right? For, like,
I'm sorry?
that's kind of almost an implicit bias, right?
Yes. Yes. Now, in that same token, you all walked in, whether it was yesterday, Tuesday, or today, and you look over at the defense table and you see my client, Mrs. Adelson, do you wonder to yourself, I wonder what she did? Number 2, you think to yourself, I wonder what she did, or I wonder what she is accused of doing?
I don't look that far into it. I mean, I don't know her from the next person, so I would just treat her like another person.
Okay. What about number 9?
No, sir, I didn't have that question.
Well, which one did you ask yourself? I wonder what she did, or I wonder what she's accused of doing?
Neither.
Did anyone ask that question of themselves, or say that to themselves? Number 23.
Yeah, I was wondering, you know, what she is accused of.
Okay. I saw a paddle over here. Number 25. What did you think?
Yeah, like initially, I mean, it's just human nature to be curious. It's like, I wonder what this person was accused of.
Now, do any of you have anxiety or are claustrophobic that if you're in lengthy deliberations that you might want to just leave the jury room? Anyone at all? Now, going back to implicit bias briefly, does everyone here agree, and let's start on the first row, that you will make an effort to be conscious of implicit bias when you're considering the evidence in this case? Second row. Third row. Thank you. Now, when we were back in the jury room the last couple of days, some of you answered some of the questions. I think I might be able to, or I believe so. And you recall that we asked you to clarify that. First row? Okay. Why do you think we asked you that? Anyone?
Gauging our levels.
Because sometimes, I'd say just about every day in our lives, we face bias because we have a perspective of what the world should be, and we can only deal with bias if we can consciously are aware of how we feel and what's going on around us.
Thank you. Does everyone agree with that response? I need verbal.
Yes.
Thank you. So if a witness were to say, I think I saw this, is that the same as them saying, I saw this?
No.
Another important point, and I want to go to number 6. If you are selected as a juror and you hear the evidence and testimony, you go back into the jury room, are you able to say to another juror, well, that witness didn't say that they saw it. They said that they thought that they saw it.
Yeah.
Or they didn't tell you what somebody said, but what they think they overheard. You can point that out. Number 12. Could you do that as well?
That's my duty. That's why I'm here.
I'm sorry?
That's my duty. That's why I'm here.
Number 11.
Good.
Number 16. Yes?
Yes.
Number 17.
Yes.
Ms. Kappelman covered the leader, so some of what I was going to cover has already been addressed, so I'm not going to repeat it, and certainly not here to waste your time. Number 23, would you say that you're naturally skeptical?
Yes.
Okay, when I ask that, what do you think that I mean?
Like, today's going to be a great day, and sometimes you're like, yeah, there's something can go wrong. You better not, put all your eggs in one basket, so to say, and think everything's going to be great. You have to be open and know things can go wrong.
Do you question when somebody says something to you? Would you question whether or not they're being honest?
Yes.
How do you determine whether or not they're being honest with you?
The normal things, look a person in the eye, if they're fidgeting in their seat or, not able to stay still or, they have conflicting statements or whatever.
Let's see. Number 19. Would you agree with that? Are you skeptical? Are you naturally skeptical?
Depends on the situation.
Give us an example.
Oh, well, like he said, if it's going to be a great day, I have to keep an open mind because I have no idea if it's going to be a great day or not.
You trailed off at the end.
I have no idea if it's going to be a great day or not.
Are you hopeful?
Not really.
Today might be a bad example. Now, you previously served on a jury. You said it was in California?
Correct.
Things are a little bit different out there?
A little bit, yeah.
In trials, I mean.
Well, the way you guys did this time is different. I'm assuming it's because it's sensitive information, so.
You said that you didn't want to have to do it again. Is that accurate?
Yeah.
But it wasn't a bad experience?
No, I was not. I don't know. It was different than I was thinking, but it wasn't like horrible.
Let's see. Number 13. How do you avoid misunderstandings with people?
Through conversation.
Can you give us some techniques?
Primarily through asking questions to not only hear what they're saying, but then to get at what they're intending to communicate as well. both verbally and then non-verbally.
So it's important to listen.
Yes.
Okay. Number 14. Do you agree? Any other examples of how to avoid misunderstandings? Anyone at all? I'm going to call it yes, number 16.
Being aware of what you've actually been told versus what assumptions you're making.
I couldn't hear you.
Being
Sorry.
aware of what information you've actually received versus what assumptions you've made.
Okay, so avoiding assumptions. Okay. Number 12, I saw your...
Oh, I was just going to say that it's good to confirm your understanding of what someone has said, if that's possible.
So in other words, repeating back what somebody has said to you to confirm that you understood it the way they intended.
Exactly.
Number 23. I'm sorry, number 11.
Yes, sir.
When you were falsely arrested, how did you feel about the criminal justice system?
I was a bit irritated with it at the time.
Okay. How long did it take to correct?
About 3 weeks in total. I was bailed out immediately, so I only spent about 8 hours in a holding cell, but about 3 weeks of back and forth before I was fully cleared.
It's actually pretty quickly.
I thought so, but I was rather persistent.
Number 23, you agreed that that was a pretty quick turnaround?
Oh, yes, yes.
Okay. By a show of hands, does anyone think that the state could make a mistake? Yes? What about law enforcement? What about the state's theory of a case? Does anyone think that the state can be wrong in their theory of what happened?
Yes.
Did anyone not raise their hand? 23?
Oh, no, I raised
okay.
my hand.
Just making sure. Now, does anyone know people who keep large amounts of cash on hand? That's number 26. Do they have a distrust of the banking system?
Yes.
Okay. Now, I know at least my generation, my grandparents and my great-grandparents certainly had a distrust of the banking system. The Great Depression, people lost everything, right? Okay. I think we're starting to get into a point where I might not be able to relate with some people. Number 6. Do you think that it would be inappropriate or illegal for someone to keep large amounts of cash? Let's see. Number 24. Have you ever made or received a personal call while you were around other people? What did you do so that those individuals didn't hear your conversation?
Usually ask to be excused.
You walk away?
Mm-hmm.
That's a yes?
Yes.
What if you couldn't walk away? How do you convey what you're trying to convey?
Then I usually ask if I can call back to the person.
So you would either try to walk away or you would continue the conversation another time.
Right.
What if neither one of those were options? Would you
no.
be vague?
Yeah, because if I'm trying to get, especially if I'm working, a lot of times I couldn't take a phone call, so I wouldn't answer. So.
What if the person that you're with is the one who gets the call or makes the call? How do you know what's discussed?
You can, a lot of times hear what they're talking about.
Well, what if you can't hear? They walk out and you can't hear. Do you know what's discussed?
No.
Now, if the person comes back and tells you what was discussed, do you know whether or not that was true?
No.
By a show of hands, has anyone ever said something that they regretted? Thank you. I know that nobody, and correct me if I'm wrong, but nobody here has ever worked in law enforcement, correct? Okay. Has anyone received any courses or done any type of law enforcement training? Even those that were in the military. Number 13.
Yes, somewhat.
Can you tell us?
Sidebar. It would have to be a sidebar.
Okay.
Due to the nature.
Understood. Anyone else? What about private security, private investigation? Anyone? Does anyone here like to travel? Got a few that don't. You don't like to travel? Number 9?
No, sir.
Okay. For those of us who like to travel, let me pick on somebody. Who raised their hand? Number 25. Is it generally less expensive to stay in an Airbnb or a hotel for a lengthy trip?
For a lengthy trip? I guess it depends on the area, but I guess recently Airbnbs kind of seem to be cheaper.
Now, there were a few people, and I didn't see the hands that have been involved in a divorce. Actually, number 11? You've been divorced?
Divorced?
Yes.
Yes, sir.
Okay. Did you have young children at the time?
I did.
But was it amicable?
It was.
Anyone not have an amicable divorce who's been divorced? Okay. Did you say things about your ex or soon-to-be ex that you didn't really believe?
No.
I'm sorry?
No, it was pretty cordial.
Oh, it's pretty cordial? Okay.
For me on my side.
Oh, on your side?
I was pretty nice.
What about the other side?
Yeah,
Not quite as much?
I wouldn't know.
Do you know how she spoke about you during the divorce?
Yeah.
Was it nice?
No.
And that same note, by a show of hands, has anyone ever spoken poorly or said mean things about somebody else? Pretty much everyone. Does that mean that you hated the person? Anyone? The fact that there are no paddles up tells me that doesn't mean they hated them. Okay.
I think it means we're just mad at the time.
Thank you. By a show of hands or paddles, has anyone jumped to a conclusion before? You hesitated.
Well, I don't like to admit, but I suppose I have.
We're human. We tend to do that. It's not just analytics. We also have emotions that come into play. And that's how we interpret things, right? Now, for all of us who have jumped to conclusions, was our initial conclusion always correct? No. By a show of hands, has anyone had a knee-jerk reaction? Said something in that moment? Pretty much everybody? Okay. Number 7. Did you later realize that you misinterpreted what was said? You're human. By a show of hands, has anyone ever planned a party?
Wait a minute.
visual person. So I wanted to list out some things that I wanted to talk to you about. So we're going to start with some definitions and concepts that I want to see how you interpret it. We're going to talk about the presumption of innocence, the burden of proof, jailhouse snitches, and we're also going to talk about some of the legal concepts that you're going to be asked to determine. Now, I think we've made it pretty clear. The law is going to be coming from the bench. I want to make sure that you can follow the law and that you understand what you're supposed to be doing. So I'm going to call on somebody new. Number 18. Can you tell us what a presumption is?
When you are making an assumption.
Is it an assumption? Now, it's just like the presumption of proof of innocence. You're not making an assumption there, are you? It's something that you believe up until a point, right?
Yeah.
Okay. Does everyone agree with that? So, for example, you're supposed to presume that Mrs. Adelson is innocent up to the point if the state can prove their case beyond the exclusion of a reasonable doubt. What does that mean? What is beyond a reasonable doubt? We're going to get to that. Now, Ms. Kappelman already talked a little bit about what direct evidence is and what circumstantial evidence is, right? Does anyone feel like we need to go over that again? Number 17?
No.
Okay. Now, something else that came up. The state indicated a moment ago that evidence comes from the state, an indicator of their table. Evidence actually comes from the witness stand and in the form of exhibits, things that are presented to you. It's important for you to understand what I say, what Ms. Fulford says, what either the prosecutors say isn't evidence. It's argument. Number 20. You understand that?
Yes.
Number 14? Yes. You understand that?
Yes, sir.
Okay. So, if you interpret evidence different than we argue, what are you supposed to do?
Discuss it.
I'm sorry?
Discuss it.
And you're going to discuss it back in the jury room. Good. Does everyone agree with him?
Yes.
Getting.
Yes, sir.
I have one confused look. Number 19. So if you interpret something different than what the state or defense argue it to be, what are you supposed to do?
Discuss it, like you said. We agree with.
How do you determine whether or not the state's right or the defense is right?
I don't know.
You don't know?
No.
Can anyone offer any suggestions? Yes.
Asked to review the testimony.
What else?
Reviewing the evidence.
I'm sorry.
Evidence.
Okay, so look at the evidence again.
To that point also, the court will give you specific instructions on how to weigh the evidence when we reach that point. You may continue.
Thank you. Now, presumption of innocence, we touched on it briefly. It's important. You must presume or believe the defendant is innocent. As we sit here today, you've heard no evidence. Mrs. Adelson is innocent. The presumption stays with her as to each material allegation in the indictment unless it's overcome by evidence, so by things that you're going to get up there, beyond the exclusion of every reasonable doubt. Does everyone agree with that legal concept? Shaking the heads, yes, thank you. It's the state's burden to prove that. So, a few moments ago I asked if anyone could define reasonable doubt. It's kind of, there's a definition. The judge is going to give it to you. We'll probably go over it throughout different points in the trial. But I find it easier to use some examples. Because presuming someone is innocent is not how our mind usually works. So, let's see. Number 5. Let's say this morning on your way in, you're pulling to the parking garage and you see a motorcycle cop pulling somebody over. What do you think? What do you think happened?
You presume they broke some type of traffic law or something.
You don't think to yourself, I wonder why that cop pulled that innocent person over, do you? Did anyone think that? Thank you. You probably thought, glad it wasn't me. That guy was speeding. That's the way our minds normally work. You see someone get pulled over, you're like, oh, they ran a red light, they were speeding. And as I said earlier, you may have done that when you walked into the courtroom this morning. Now, just because you think that way doesn't mean you're not qualified to serve on the jury. But it does mean that we can't have that kind of thinking interfere with part of your deliberative process. Does anyone here think that because law enforcement arrested Mrs. Adelson and the state has decided to charge her, and that we've got all the way here to trial, does that make you think that she is guilty in any way? And I'm going to start with number 22. Does that make you think that she's guilty in any way?
In a way.
In a way?
In a way. Because why the state wastes a lot of resources, time, and money to convict someone that might not be guilty.
Does anyone agree with number 22? Anyone else?
To an extent.
I'm sorry?
To an extent.
To an extent? What do you mean?
It wouldn't, in my mind, make sense for the state to spend, I'm assuming at this point, maybe 10, 11 years going after a person that they didn't believe was guilty, or that they had no reason to go after a person for that long.
Thank you for your honesty. Does anyone else agree with that perspective?
I don't think that it necessarily makes her guilty verdict, but I do think that to make it to trial at this point, there has to, at some point in our legal system, been enough substantial evidence or witness testimony or things that they found for it to be got to this point and not run out along the way. It's like, hey, there's not enough here. So there's something, but the burden of that, again, is on the jury to figure that out.
So with that in mind, is that belief that you have, is that something that you're going to carry into the jury room?
I think it's a belief that I carry into the jury room that we have to listen to that evidence and decide if it's credible or not. That's why you have a jury.
But I guess it was a poorly worded question. The fact that you believe that it's gotten this far, does that gives you some idea that Mrs. Adelson is guilty?
Not that necessarily, like I said, not that she's guilty verdict, but that there's credibility to some evidence that potentially may point that way, which is why we're sitting here today.
Okay.
I wouldn't just assume that it's just all farce.
Would you say that you're pro-law enforcement?
Sure.
So law enforcement conducts an investigation. They believe that they have probable cause. They make an arrest. You give that some weight.
Yeah.
You also said earlier that they could be wrong.
Sure.
How do we determine if they're wrong?
By what we're doing right now.
And just to be clear, the defense doesn't have to prove anything to you. Does anyone think that it's not fair that the state has the burden to prove beyond a reasonable doubt with evidence and testimony that the defense doesn't have to do anything? So let's go continue with the discussion.
Hold on one moment. Juror 26 has their paddle up.
I was just gonna say that, you know, somebody accused me of something, I'd wanna speak up and say whether I did it or not, because I want to defend myself. I mean, I want that opportunity to say, yes, I did, or no, I didn't.
And that's fair. Now, concept in our legal system is the defendant has the absolute right to remain silent. The judge is going to instruct you that if my client chooses not to testify, you can't hold that against her. Can you follow that instruction?
No, it's, oh yes, definitely, yeah, just personally I think that, you know, there should be some kind of response, but you're obviously the response for this.
Certainly, and I think that's human nature, that if someone says, you know, well, you did this, we want to speak up and defend ourselves. But in a courtroom in this country, the defendant doesn't have to do that.
I think there's a time and place to speak up about things.
I don't disagree. Are you going to hold it against Mrs. Adelson if she doesn't testify?
Absolutely not.
Would anyone here hold it against Mrs. Adelson if she chooses not to testify? So let's go back to what beyond a reasonable doubt means. I'm going to give you another example. We've been in here for a while. There are no windows to the outside. So we walk outside when we're done, and the sidewalk and the road is wet. Is it reasonable to think that a fire truck drove down the road and sprayed everything to get it wet? Anyone thinks that's reasonable? No. That's not reasonable. In that context, can somebody volunteer what would be reasonable?
It rained.
Wait, we're in Florida. Does that happen?
Every day.
So we're defining what is reasonable. Does reasonable mean likely to happen? Is that what the judge is going to instruct you? Number 2. So would you disagree with the statement that proof beyond a reasonable doubt means most likely to happen?
No, yeah, it's not most likely to happen. There's rarely like a case where it has every single aspect of evidence to it to fully convict someone because it would always be able to do it.
You know, I've been using these examples for a long time, and I think this is the first time that I haven't had to come back and say no, because most people would agree with likely. Standard is not most likely. It's not probably. It's not most convincing. So there are different levels of proof. And I think that you heard either the judge or Ms. Kappelman at some point talk about this. So at the bottom of the scale is reasonable suspicion. That's what's typically enough for an arrest. Or, I'm sorry, enough for an officer to stop someone, pat them down. Probable cause, what's necessary to get a warrant. Okay, so now, where on that scale we are, who knows? But that's enough to get a warrant, enough to arrest somebody. You got preponderance of the evidence, which is a civil standard. It's more likely than not. And you have clear and convincing evidence. That is what's required for the state to take your children from you. And at the top of that scale, it's beyond and to the exclusion of every reasonable doubt. That's the standard. So when you think about the state's burden of proof, how do you think about that from an operational standpoint? What is the state required to do? So let's go back to the chart. Who have I not called on? Number 8. Is the standard that you're going to be carrying forward into that jury room decide which convinces me the most?
No, your side doesn't have to convince me of anything. It's only the state that needs to provide evidence.
Can both the state and the defense make arguments that you disagree with?
Oh, sure. Everyone makes arguments.
That you believe the evidence does not support?
They could, yeah.
What are you going to do at that point?
Reconsider the evidence, deliberate with my peers.
And if the state has only proved something probable or possible, what are you going to do?
Well, it really needs to, I gotta get the abiding conviction of guilt. So I really need to feel that conviction that your client would be guilty after seeing all the evidence and testimony.
But that's exactly my point. If the state doesn't do that, you stop. It's not guilty. You understand that?
Yeah, that's what it says. Yeah.
So, in the definition, one of the words that you're going to see in there is exclusion. The state has to exclude every reasonable doubt. They have to eliminate it. Does anyone here at all, starting on the first row, believe that they're going to have a hard time holding the state to their burden? They have to exclude every reasonable doubt. Anyone on the first row? Second row.
So when you say that, you mean that the state has to discount every other possible, like exclude to the exclusion of a reasonable doubt? Like prove to me that it's not possible?
Not. Don't use the word possible.
Okay.
So if in argument the defense were to say, give alternatives or a different explanation, and you believe that to be a reasonable doubt, if the state doesn't exclude that, then what is your response going to be?
Okay.
Does that make sense?
Gotcha. Thank you.
Does everyone understand that? I can make it real easy.
Before you go to the next one.
No, I can go past it. Yeah. Not to the next slide yet. Okay, so one of the things that the court's going to instruct you is that a reasonable doubt arises from the evidence, a conflict in the evidence, or a lack of evidence. So this is another place where I like to use a hypothetical. And for this one, we're going to adopt the bank robbery hypothetical that Ms. Kappelman was talking about earlier. So the hypothetical is someone goes in and robs a bank. Witnesses identify the defendant. There's obviously surveillance video showing somebody that is consistent with the defendant's features. So
please approach. Prospective jurors, we're just going to take a brief break for the moment, give you an opportunity to stand up and stretch your legs if you need to. I recognize that we are going through this process, and it has been lengthy. If you need to stretch or take a moment to do so, you have the opportunity right now. 5 minutes. Be quick.
So I'm going to start that hypo over. So reasonable doubt can arise from the evidence, a conflict in the evidence, or a lack of evidence. And so the hypothetical, the bank robbery, someone goes in, witnesses identify the defendant from the stand, video evidence shows the defendant on the surveillance. Closing argument, the defense attorney gets up and argues that the state didn't put on any evidence to show that it wasn't the defendant's twin brother. How do you know it wasn't his twin? What kind of doubt would that be? Let's go to number 20. What kind of doubt would that be? Does anyone agree with her? Number 23. You grimaced. Oh, I'm sorry. I keep confusing these two. The chart's different. Number 11.
Yeah, that's a tough one. I don't know.
That's speculative. There's been no evidence the defendant has a twin. Now, the defendant took the stand in that case, testified that he has an identical twin brother who is a bank robber, and oh, by the way, I have an alibi. Now it's evidence. You understand the difference? Yes? Okay. That is a doubt which attaches to the evidence from the witness stand that was admitted during the trial. Reasonable doubt. Now, what would the state have to do about that reasonable doubt in order to convict that defendant? They'd have to exclude that doubt which attaches to the evidence.
His fingerprints versus his brother's?
We're going to get there. Thank you. So let's go back to that hypothetical. In the surveillance video, and the witnesses testify that the robber is wearing a mask, so no one can identify him. Whose fault is that? Is that the state's fault? Number 8, is that the state's fault?
He's wearing a mask.
Yeah. They can't prove who it is. Whose fault is it?
The burden would be on the state.
Right. So there's no identification. So the lack of identification is what? Reasonable doubt.
Yeah.
Let's go back to that same hypothetical. You got a mask. Robber's not wearing gloves, and he touches the table, he touches the glass door. You can see all that in the surveillance video. It goes to your fingerprint question. But reasonable doubt can arise from the lack of evidence. In this hypothetical, the detectives never bothered to dust for prints. Would everyone agree that that would be a lack of evidence which bears on a material element of the offense, identity? Would everyone agree to that?
Yes.
And that the state has failed to exclude that by not gathering the evidence. Does anyone disagree with that? Now, go back to the same hypothetical. Surveillance video shows that the robber is on his phone. The witnesses tell law enforcement that the robber was talking to somebody. Law enforcement later seizes that robber's phone, but they never search it to determine if there was a text or call made. Would everyone agree that there's a lack of evidence there?
Yes.
Another way the reasonable doubt can arise is based on a conflict in the evidence. In the hypothetical that I just gave you, can someone identify any potential conflicts? Can you?
Not off the top of my head.
What if they were to dust the table or glass for fingerprints, but it's not conclusive?
What if the guy was somebody who visited the place earlier and could be seen doing the exact same thing?
Now the state, well, before we move on, does everyone agree that witnesses that are going to come and take the stand are not perfect, they're not actors? Does anyone expect to see what you would see if you watch a TV program or a movie? Number 13, you were smiling.
I am. I think before stepping into this whole process, there's an idea in your head that's put in there by culture on what it all looks like. But when you step in, it kind of is shattered when you go into the jury selection process right away. So, yeah, it's the difference between make-believe and reality.
And this is what?
This is reality, not entertainment.
Judge is going to instruct you on how to weigh the credibility of witnesses. Now, the state brought up a point, this is something that happened 11 years ago. Does anyone think that if someone doesn't have an accurate memory, that that's something that's going to matter here? Number 22. That's going to matter?
If the person doesn't have accurate memory, yeah, it will be matter because it will distort the whole information of the evidence you're going to provide to the juror.
Sorry, say the last part again.
Say that the information that you're going to provide to the juror will not be accurate.
How do you determine if someone is giving you an accurate answer? Would you compare it to the other evidence?
You cannot really tell.
I'm sorry.
So you cannot really tell unless you have the videotape or something that you can go back and review.
One of the instructions the judge is going to give you is you can believe or disbelieve any testimony from any witness. Okay? Ms. Kappelman talked a little bit about co-defendants. I'm going to talk about something else. Informants. I call them jailhouse snitches. Why would a jailhouse snitch cooperate with the state? I'm going to call on somebody I haven't called on yet. I think I've called on everybody. Number one, what would motivate a jailhouse snitch?
Special treatment?
Okay. Like what?
I don't know. What kind of amenities can they give? Maybe less time or comfort?
In evaluating the testimony of an informant or a snitch, should you consider what benefit they got in determining whether or not they're being truthful? Number 8, I saw you shaking your head or nodding.
Well, I mean, somebody can be getting a kickback and be telling the truth at the same time.
What do you mean?
I mean, they could have seen something bad happen and get a reduction in the sentence for telling on them. It doesn't mean that the person did something bad or did not do something bad.
So they could get the benefit, but it doesn't mean that what they're saying isn't truthful?
Yeah, I mean, they could be lying or telling the truth. Just because they got, a benefit or anything doesn't weigh on that other side of the equation in my mind.
Pretty briefly approach.
going back on the topic of informants or snitches. We had one opinion that just because they testify doesn't necessarily mean that they're being dishonest. Or honest. Okay, so we don't know. How do you determine whether they're being honest or dishonest?
The other evidence is presented, as well as their body language.
You got to weigh what they're saying against the other evidence, right?
Yeah.
Okay. Now, if you were to learn that the state can offer a benefit to an informant or a snitch, and it could be financial, could be favorable treatment, or anticipation of favorable treatment. On a scale of 1 to 10, with 1 being unfair and 10 being completely fair, where do you find yourself? And I'm going to go number 7. Is that fair or unfair?
6.5, 7.
Number 6. Number 5.
Probably 5. I find it either fair or unfair, depending on the situation.
Number 22. It'd be balanced.
Yeah.
Okay. Number 4. Yes. Number 24.
5.
5. Number 2.
Would you repeat that question?
On a scale of 1 to 10, with 1 being unfair and 10 being completely fair, where do you find yourself? If you were to learn that the state compensated or gave a benefit to an informant.
That would be fair. For sure.
Okay. Number 1.
Scale of 1 to 10?
Yes.
6.
Number 8.
Initially, I feel like it's unfair, but when you think about it, no one does anything for free, and there's going to be a lot of risk to, coming out against a lot of folks that also could be in jail.
So it's a balance?
Yeah, it's a risk versus reward, and I think the higher the reward, the more of a risk someone is willing to take for that reward.
Does everyone agree with that?
Oh, yeah.
Getting a lot of head nods. Okay. Number 9.
I'd say it's about equal. 5.
23.
I agree with mostly what he said. If it's
Are you referring to number 8, sir?
yes.
Go ahead.
Number 11.
Number 5.
Number 12.
I'm gonna have to say 4.
Number 13.
I think I'm in the 4 or 5 range.
Number 14.
I think I'm like a 7. I think it's fair.
I'm sorry?
I'm like a 7. I think it's fair.
Okay. Number 25.
I'd say it's a 4 because the state then has more influence to pressure, whereas the other side would not have that same advantage.
Number 20. Can't read my own handwriting. Ma'am.
I'm 25. I think you said she was 25.
Yeah.
Just so you know.
Yes. Thank you.
About a 5.
About a 5?
Yeah.
20?
5.
19?
5.
18?
Is it legal?
It's legal.
Then it's fair.
Okay. Number 17?
You can go with 7 as well.
16?
It'd be hard for me to say, just that general circumstances really depend case by case.
Okay. Just a moment. Does anyone think that the defense should have the same benefit there? The defense can do that as well? No? I'm sorry?
Could you explain what you mean?
Could the defense offer a benefit to a witness? If I were to tell you that we can't. Number 24. Is that fair that we can't do that?
I know that cannot. Yeah.
Right. Is that fair?
I don't know. I just know as the law you cannot.
Right. Number 14.
I think it's fair because the burden's on them to prove their case.
Fair. Now, has anyone here heard that a description of the role of a juror as having a duty to deliberate about the facts? Anyone? Getting some slight head nods. And once you decide the facts, you apply the law to those facts. What does deliberate mean? Let's see. Number 19, what does deliberate mean?
Discuss the facts of the case with your fellow jurors.
You trailed off at the end, I'm sorry.
To discuss the case with the fellow jurors in the jury room.
Does everyone agree with that? Yes. What does it take to deliberate? Do you think carefully? Consult with each other? Getting some head nods? Does anyone here, bless you, anyone ever engage in a family discussion around the dinner table? Show of hands. Are there informal rules for that?
Yeah.
Number 7. What are the rules at your house?
Well, my dinner table has a 8-year-old, 6-year-old, and 2-year-old. So right now the big rule is don't talk over your siblings, and everybody gets to tell their part. Everybody gets a voice to be heard.
And I've had children that age before. It can be somewhat difficult to wrangle them. How do you encourage them to follow those rules?
Sometimes with stern authority, but most of the time with the illustration of, hey, you want everyone to listen to you when you're talking, so you need to be quiet while your sister talks. I try to model that for them myself too.
Okay. So you redirect them. Sometimes you got to be stern, but you try to redirect them, and you try to use your own methods of showing them an example. Okay. Now, for those of us who have older children, let's see. Number 11. I know what it's like to have 4 children. How did you determine whether the family discussion was successful?
Well, I guess if we were all still speaking to each other and after the discussion took place was a success in my house.
I can relate. Now, would it be accurate to say that the end result, the conclusion that is reached, coincided with your initial conclusion?
Not necessarily.
Now, if you felt strongly that your way was the right way, would you be capable of standing up to them and saying, I believe this, I hear you, I respect you, but I disagree?
Absolutely. And that's exactly how it was in my household. You have the right to your opinion as well, and let's all try to understand each other and respect each other in that regard.
So in other words, can you accept that sometimes we just don't reach an agreement?
Absolutely.
Now, number 6. think you touched on this a little bit earlier, but if you are engaged in that conversation and you disagree with everybody else's conclusion, but it's 6 o'clock on a Friday and you're hungry, are you going to change your opinion so you could go get something to eat? I don't think so. Does everyone remember why that statement causes me concern? Are you going to change your opinion? Anyone here willing to change their opinion if they believe that their interpretation is correct? Anyone? Getting crickets.
I'll change my opinion if the evidence suits it. My opinion's not set in stone or anything.
Well, let's back up a little bit. If you believe strongly, after having this discussion, that you're right, are you going to change your opinion so that everybody can go home?
I mean, there'd be a lot of peer pressure. I could see that, but I mean, me personally, my opinion goes out in the publication on all kinds of stuff that we stake our reputation on that as PhDs. So only good concrete facts really change my opinion.
So, short answer would be no, you wouldn't change your opinion.
No.
Would anyone change their opinion so that they could go home? I'm getting shake. Okay, great. Are there topics that you should not discuss when you're back in the jury room? Anyone want to volunteer an example?
Anything you may have heard secondhand inadvertently through somebody, work, home.
What about whether the defendant should testify? Is that something that you should discuss back there? What does it mean if the defendant doesn't testify? You discuss that. Number 7, should you discuss that the prosecutor decided to charge Mrs. Adelson? Well, you said earlier that if we've gotten this far, that it means something, right? Should that be something that you discuss?
No, I just think that's something that gets us to the trial. And the only thing we're discussing is what happens in the trial.
Does it matter what clothing I wear or my client wears? Is that something that you should discuss back there? Okay. Trying to find somebody to pick on for this. Number 13. Can you give me a definition of something that's, an example of circular reasoning?
It's an argument that plays back on itself. So the argument is used as the evidence or proof that the argument is true.
I'm going to give you an example too. I like that one. I don't think everyone's going to agree with me on this, but good guys don't make mistakes. Law enforcement officers are good guys or gals. Therefore, law enforcement officers are good, I'm sorry, let me back up. Good guys don't make mistakes. Law enforcement officers are good guys. I'm a law enforcement officer. Therefore, I don't make mistakes. Circular?
I agree with that.
It's not accurate, is it?
Right.
Do we want to avoid that type of reasoning when you're deliberating? Anyone disagree with that? Does anyone think that law enforcement officer who testifies should be believed over somebody who's not a law enforcement officer?
No.
Anyone? Number 17?
No.
No?
No.
When you're back there, would you be deliberating if you automatically accepted as truthful, without the exercise of any skepticism, the testimony of a law enforcement officer? Number 17.
Ask me again, please.
Would you automatically believe testimony of a law enforcement officer without exercising any skepticism?
No.
You wouldn't be deliberating, would you? You're just accepting what they tell you. You got to question what is said to you, what is presented. Do you agree with that?
I did.
Does anyone disagree with that? Just going to accept what is presented by the witnesses. Anybody? Good. Now, I'm going to go back to you, number 8. When you're deliberating, you have concluded your conversations. You believe that you're right. You said that you're capable of standing your ground, right?
Yes, sir.
Okay. Now, what about the reverse? You go back there, you believe steadfast in your position, but then somebody else adds something that you hadn't considered. Are you going to then consider that as part of your deliberative process?
Yeah, that's the whole goal. Certainly.
One of the instructions that you'll get from the court says that you should use your common sense. Is common sense a process, or is it a result? Let's see, who do I want to use for this one? Number 2.
Well, I say it's a process.
And so if common sense is a process, should you automatically accept the state's conclusions without discussing it? What should you do?
I mean, common sense might be common, but it's not always the answer, so you could have something different. So you need to be skeptical of everything. Even common sense can be wrong sometimes. So.
Are you capable of saying, if someone's common sense result, their process, leads them to one conclusion, but your common sense process leads you to another, how do you resolve that? Or can it be?
Go back to what you assume is common, the common sense, and kind of discuss those. What's so common about it? What are you hinging the common part of it on? Like, what do you actually think is so reasonable about it?
Thank you. Ma'am?
Number 26. Go ahead.
I don't think we can, in all fairness, always trust our common sense, because I think we all have to say we have common sense, but circumstances change, and when circumstances change, we need to rethink whatever our common sense is telling us.
Fair. Does anyone agree with that? Give me some nods. Anyone disagree with it? Now, you've heard the court read the charges against my client. One of the things I want you to understand is what's going to be necessary as you are evaluating the evidence. Ms. Kappelman asked, how do you determine someone's intent? Everyone remember that? It's not just, does somebody always say what they intend to happen? You're shaking your head? How do you determine that? With their words?
Yeah, that's part of it.
clear is throughout the case, everyone understand that you don't reach a conclusion until you don't start deliberating until after all the evidence. Okay, so when you get to that point, all the evidence has been presented. At that point in time, you guys then have the opportunity to go back and discuss what the evidence means. Does everyone understand that? Shaking the heads, yes. Now, if the state establishes that there's a premeditated killing of Daniel Markel, and that Daniel Markel is dead, does that mean that it was done by the criminal act of my client? You need to be able to separate my client from the other individuals. Does everyone understand that? Principle. Ms. Kappelman discussed it earlier. The important thing to take from this is the state's going to have to establish Mrs. Adelson had the conscious intent for Daniel Markel to be killed. How do you determine if someone has that? Number 5. How do you determine if that happens? How do you determine if the state can prove that?
There would have to be some sort of evidence, like witness testimony, writing, something along those lines, that there was premeditation, some sort of plan.
Now, in the principal instructions, the state's not going to have to prove that Mrs. Adelson was present. Have you heard the term guilt by association? Anybody? Oh, yeah. Shaking the head, yes. Now, there's going to be testimony that my client's son, Charlie Adelson, was convicted. Does that mean, and I want to, anyone, does that mean that my client has any involvement, that she is guilty? Shaking your head, no. Anybody saying yes? Is that conclusive in any way concerning Mrs. Adelson? Shaking of the heads. Let's see. Number 7. Is that a factor that you're going to consider when you're evaluating the evidence?
Can you ask it again?
Sure. The fact that my client's son, Charlie Adelson, has been convicted of these charges, is that something that you're going to consider when determining whether or not my client is guilty?
Sitting here right now, no, but if the state uses some sort of, I mean, it would just be determined on if the state has a connection or if they present some evidence, that would have to be considered.
Is it conclusive?
No.
So what you're saying is the state would have to have evidence connecting Mrs. Adelson to her son's actions.
Sure, yeah. Just can't do
They
anything
would
on it.
have to have evidence beyond a reasonable doubt.
Yeah.
Does everyone agree with that?
Yes.
Anyone disagree? Just because he's been convicted doesn't mean that my client is guilty.
Correct.
Before we approached, we were discussing other people's responsibility. There's only one person that's going to be on trial here. Does everyone understand and agree that your feelings about anybody else and whether or not they have any responsibility have nothing to do with Mrs. Adelson's responsibility? Everyone can separate that. Focus your conversations only on Mrs. Adelson. Does everyone agree? Let's see. Looking for somebody with older children. Number 11, I'm going to pick on you again. Kids ever lie to you when they were growing up? Say it again.
Absolutely.
How did you determine if they were lying?
I had pretty good kids, so normally they felt guilty enough to come tell me to me. But typically, as a parent, it's fairly easy to pick up on when your kid lies to you for the most part. The older they got, the more difficult that was. But
so your children are adults now?
Correct.
They ever lie to you as adults?
Oh, I'm sure they do.
Have you caught them yet?
A few times.
Number 16, how do people react when they're scared?
Very much depends on the person. Someone's going to have a lot of big emotions. Someone else might kind of go into a fawn response.
Some people don't react the same.
Sorry?
People don't react the same when they're scared.
Correct.
Everyone agree with that?
Yes.
And I grew up in Miami, and I had a friend whose family was featured on a reality TV show after Hurricane Andrew. He quickly discovered he didn't like that type of attention. Anyone experienced something similar where they've been in the spotlight and they didn't want to be there? Number 16, you're shaking your head yes. You've been in the spotlight before, you didn't want to be there?
Was on local news as a kid, didn't like that.
I'm sorry, I couldn't.
Yes, a little bit. When I was a child, I was on local news and got very shy during that.
Okay. You wanted to get away, right? Does everyone understand that that feeling you want to get away from unwanted attention? Yes? Now I'm going to ask you something I don't normally ask in jury selection, and I apologize if I offend anybody. By a show of hands, anyone familiar with Judaism? Thank you. Are there important life events that happen in the lives of Jewish children? Was your grandmother at yours?
I'm not Jewish.
Oh, okay. My grandmother was at mine. I'm going to bring up something else that's a little unique. And who was familiar with Judaism? Okay. Number 12? That's you? Oh, 14. I don't know why I can't keep this straight. I'm sorry.
That's all right.
Actually, I'm going to skip that. Let's see. During the course of the trial, there are going to be some photographs shown of Mr. Markel, is anyone particularly averse to gory scenes? Nobody? Number 9? Can you talk to us about that?
I get fairly squeamish about that kind of stuff. I'm not passing out the sign of blood, but other stuff that are more gruesome is just a bit unsettling.
Okay. Is that something that you wouldn't be able to review that evidence?
I should be able to review that evidence.
Should be?
Yes.
Or will be?
Will be able to.
Okay. Is that going to impact your ability to be fair in evaluating that evidence?
No, sir.
I want to ask a somewhat provocative question. At this point in time, does anyone here believe the state actually knows what happened? Anybody?
Say that again?
Do you believe the state knows what happened? Sure. As we sit here today, now remember, prosecutors were not witnesses to this case, correct? They are going to present arguments to you, correct? So as we sit here, do you believe that they know what happened? Or do they believe what happened? You understand the distinction? Does everyone understand that?
Yes.
Okay. Just a moment, Your Honor. Two heads are better than one becomes 3 heads are better than one, Your Honor. And nothing further.
Kappelman, do you need to make any inquiry of Juror 26?
Dan, were you able to follow the discussion when I was doing my presentation? As far as we talked about principal theory, I gave my circumstantial evidence demonstration with the cheesy donut example. Anything that you felt like as you were sitting out there listening, oh, I would definitely interject at that point? Or has your mind been numbed so much at this point you can't harken back that far?
I was listening to everything you were saying. I mean, I I would have interjected at the moment. I was thinking, I want to say this, but don't want to say. I couldn't say it, but you know, I would always consider a person's character when I as to whether I believe them or not.
So in the context of, oh, you're going to hear from some witnesses who've been convicted of felonies, who live a different lifestyle from you, that kind of thing, is that the discussion where you were having that thought?
I try to be open-minded, and I think there are all kinds of people, not everyone, so I don't want to prejudge a person because I don't know what the circumstances are. That's why I go to ponder the evidence and decide from that point.
Okay, so can we agree then that although that's those types of characteristics or character, as you said, are something to consider, they're not the end-all be-all, and you can keep an open mind to the testimony. Does it fit with the other evidence in the case? That sort of inquiry.
Definitely, I think considering everything is
Okay. As opposed to being the type of person that, oh, I hear they're a felon, I'm done. I can't hear anything they have to say.
I think that's a very negative thinking to think that way.
Anything else during my time up here where you were bursting at the seams to share something with me? Okay. Thank you. Nothing further.
If the parties at this point can join me in the jury room along with the court reporter. For everyone else that is going to remain in the courtroom at this time, I'm going to instruct you once again, do not discuss the case with each other or anyone else. If you do need to stretch your legs or use the restroom, you may do so, but you do need to return to this courtroom. We're in courtroom 3G. No one is to take a tour of the courthouse by themselves. Please come back to courtroom 3G as soon as you finish with the bathroom, using your phone or stretching your legs if you need to. If the parties can please join me in the jury room. jurors that have been excused at this point, you will be free to collect your things, and you will not have to return at any other point during this process. Oh, let me allow the court reporter to get so. Madam Court Reporter, sorry to get ahead of you. At this time, I'm going to announce the numbers that have been excused, and you will not need to return for any further jury service in this matter. We give you our sincere thanks for honoring your summons and participating thus far. Juror 24, you are excused. Juror 22, you are excused. Juror 6, you are excused. Juror 7, you are excused. Juror 8, you are excused. Juror 9, you are excused. Juror 12, you are excused. And Juror 26, you are excused. Watch your microphones. Juror 19, you are excused. And Juror 16, you are excused. We are also going to reconfigure the box at this point as well. Juror 5, please shift down next to Juror 2. Juror 23, take the seat to the left of Juror 5. Juror 11, take the seat next to Juror 23. Juror 13, please come down to the first row and sit next to Juror 11. Juror 14, please take the last seat on the first row. Juror 17, please shift down to take the seat on the second row closest to the wall. On the second row. Yep, that's it. Juror 18, please take the seat next to Juror 17 on the second row. Juror 20, please take the seat next to Juror 18. Juror 25, please take the seat next to Juror 20. When you hear your number, please walk up and take the first available seat. Juror 27. Juror 28. Juror 29. And last for the second row, Juror 30. The seat closest to the wall on the third row, Juror 31. Juror 32 to follow. Juror 33 after that. Once you are seated on the third row, if you can hold up your paddles so I can ensure you're in the right positions. 31, closest to the wall. 32, next to her, thank you, and 33 right there. Juror 34, please come up as well. Juror 35. And Juror 36. It will be another few minutes before we resume. If anyone needs to use the restroom, please do so at this time or stretch your legs. We will get started as quickly as possible. Once again, you are not to speak to each other or discuss this case while we are still going through this process. We will resume in a few minutes. For our newly seated jurors, starting with 27 and going through 36, I'm going to need to ask you some of the same questions that were asked to the group earlier concerning your prior jury service, any connection to the attorneys or the defendant, and also some brief biographical data from you. Once we've accomplished this, the attorneys will each have an opportunity to speak with you as well. I am not going to reread the law to you concerning the presumption of innocence, the right to remain silent, and the burden of proof. The law is fixed. Nothing has changed with it. Does anyone have any questions concerning the law that was previously read for jurors 27 through 36? Please raise your paddles if you have a question as to what the court read. Very well. I'm now going to ask 27 through 36 as a group, have any of you previously served on a jury? Please raise your paddles if you have. Juror 28, please tell us where and when you previously served on a jury.
Approximately 18 or 19 years ago.
Do you recall if it was a criminal or civil proceeding?
Criminal.
Do you recall the charge or the type of case? Without telling us the verdict, did the jury reach a verdict?
Yes.
Were you the foreperson of that jury?
No.
Did anyone else have their paddle raised for having previously served as a juror? No other paddles are being raised in response. As to the attorneys on this matter, are any of you, and I'm referring to jurors 27 through 36, related by blood or marriage to any of the attorneys, or do you know any of the attorneys that were previously introduced this morning?
No, sir.
Right. No response has been given in the affirmative. Concerning the defendant, are any of you, 27 through 36, related by blood or marriage to the defendant, or do you know the defendant personally?
No, sir.
Concerning the names of the potential witnesses that were read earlier today. As to 27 through 36, do any of you know the witnesses that were identified by the parties?
No, sir.
And now I will go through your biographical information. Juror 27, what is your occupation or type of work?
Owner and operator of a online marketing agency.
Right. You'll never get advertising better than this. Shout out that name. Go ahead, give us the name.
eVision Media Group. eVision Media Group.
What is your marital status?
Married.
What is your spouse's occupation if they work?
Physician assistant at Capital Regional.
Do you have children?
Yes, 2.
And what are their ages and do they work?
22 and 12. The 22-year-old does work, full-time student at UCF and is working at student housing.
And the 12-year-old is just at home?
Just at home.
Yes, sir. How long have you lived in Leon County?
13 years.
Do you have any close friends, neighbors, or relatives that work in law enforcement?
Close friends, yes.
Have you, any close friends or relatives, ever been charged with a crime?
Yes. My brother was indicted, a federal indictment on fraud.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes. My aunt was murdered 17 years ago, and a close friend of mine was also murdered.
Thank you.
The last one? A close friend of mine was also murdered.
Juror 28, what is your occupation or type of work?
I'm retired, environmental manager.
What is your marital status?
Widow.
Do you have any children?
Yes, sir. 26 on Saturday, Sunday. Works for Civitech.
Right. How long have you lived in Leon County?
About 21 years, sir.
Any close friends, neighbors, or relatives that work in law enforcement?
No, sir.
Have you, any close friends or relatives, ever been charged with a crime?
No, sir.
Have you, any close friends or any relatives, ever been a victim of a crime?
No, sir.
Thank you. Juror 29, what is your occupation or type of work?
Project manager for a civil engineering firm in town.
Right. Once again, no better free advertising than what you have right now.
DRMP.
What is your marital status?
Married.
What is your spouse's occupation if they work?
She works with the Department of Health.
Do you have children?
Yes, 2, 8 and 12. They do not work.
Do they owe you money?
I probably owe them money someday, but no.
How long have you lived in Leon County?
All my life, 40 years.
Any close friends, neighbors, or relatives that work in law enforcement?
Yes.
Have you, any close friends or relatives, ever been charged with a crime?
Yes, close friend.
Have you, any close friends or relatives, ever been a victim of a crime?
My wife's uncle was shot and killed probably 10 years ago.
Right. Thank you. Juror 30. What is your occupation or type of work?
I'm unemployed, but I'm a social worker.
If you can say that again, they could not hear you.
Unemployed, but I'm a social worker.
What is your marital status?
Single.
Do you have any children?
No.
How long have you lived in Leon County?
Off and on for 11 years.
Any close friends, neighbors, or relatives that work in law enforcement? Have you, any close friends or relatives, ever been charged with a crime?
No.
Have you, any close friends or relatives, ever been a victim of a crime?
My parents auto theft.
Thank you. She said her parents' auto theft. For everyone on the panel, if you can remember to do this, please speak up and speak clearly so you can be heard. Juror 31. What is your occupation or type of work?
Data analyst, Department of Transportation.
What is your marital status?
Single.
Do you have any children?
No.
How long have you lived in Leon County?
A year, 8 months.
Any close friends, neighbors, or relatives that work in law enforcement?
No.
Have you, any close friends or relatives, ever been charged with a crime?
My brother has DUI.
Have you, any close friends or relatives, ever been a victim of a crime?
No.
Thank you. Juror 32. What is your occupation or type of work?
I work part-time at a restaurant.
What is your marital status?
Married.
What is your spouse's occupation if they work?
He's the owner of a restaurant in town.
Shout out that name.
Carrabba's Italian Grill.
Do you have any children?
Yes, there are 2. I have a 17-year-old and an 8-year-old.
Right. Does your older child work?
He does not.
How long have you lived in Leon County?
8 years.
Any close friends, neighbors, or relatives that work in law enforcement?
Yes, sir, retired.
Have you, any close friends or relatives, ever been charged with a crime?
I have a brother that was charged with DUI.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes, we had a masked individual try to break into our home earlier this year.
Thank you. Juror 33. What is your occupation or type of work?
Deliver and install appliances.
What is your marital status?
Single.
Do you have any children?
1.
What is your child's age?
9.
I assume they don't work.
Nope.
How long have you lived in Leon County?
They are born.
Any close friends, neighbors, or relatives that work in law enforcement?
Yes.
Have you, any close friends, relatives, ever been charged with a crime?
Yes.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes.
Thank you. Juror 34. What is your occupation or type of work?
I operate our 2 family-owned businesses for the record reporting and bouncers of Tallahassee.
What is your marital status?
Married.
What is your spouse's occupation if they work?
He is a law enforcement
Do you have children?
I do.
What are their ages and do they work?
16 and 13, and no, they do not work.
How long have you lived in Leon County?
36 years.
Do you have any close friends, neighbors, or relatives that work in law enforcement?
Other than my husband.
Have you, any close friends or relatives, ever been charged with a crime?
No, sir.
Have you, any close friends or relatives, ever been a victim of a crime?
No, sir.
Thank you. Juror 35, what is your occupation or type of work?
Delivery truck driver.
Couldn't hear that, Your Honor.
Delivery truck driver. What is your marital status?
Married.
What is your spouse's occupation if they work?
Customer service coordinator for a truck company.
Do you have children?
No.
How long have you lived in Leon County?
3 years.
Any close friends, neighbors, or relatives that work in law enforcement?
No.
Have you, any close friends or relatives, ever been charged with a crime?
No.
Have you, any close friends or relatives, ever been a victim of a crime?
No.
Thank you. Juror 36, what is your occupation or type of work?
Excuse me, I'm a little under the weather. I'm a fiscal specialist for the state of Florida. I actually work for People First.
Okay. You're not contagious, are you?
I hope not. It's
Go-
just
go-
on
go-
this cold air.
Go ahead and put that mask on then.
But I wanted y'all to hear me.
What is your marital status?
I'm single.
Do you have children?
I have one son, the age of 10.
And I assume he does not work.
No, sir.
How long have you lived in Leon County?
I would say, I've been in Tallahassee for the last 17 years. I had went back to Fort Pierce, Florida for a year or two for school, and then I came back. So I've been enough.
Any close friends, neighbors, or relatives that work in law enforcement?
No, sir. My step grandfather was a state trooper, but he's retired now. That's the only officer that I'm aware of.
Have you, any close friends or relatives, ever been charged with a crime?
Not me, thank God. But yes, I had it. My dad, my sister, and my brother. This was years ago. I'll say back in 2004 was my dad, and then 2005 and 6, my sister and brother.
Have you, any close friends or a relative, ever been a victim of a crime?
Not me, a friend has been, and that was basically, she was a minor, and I had to basically be summoned to vouch that someone violated.
Judge, I'm sorry.
If you can repeat that, go ahead.
So it was I would just say a friend of the family. I was subpoenaed because she was minor, and I witnessed her being abused, and I'll just put it that way.
Thank you.
You're welcome.
Once again, for our newly seated jurors, I am not going to read the jury instructions concerning the burden of proof, presumption of innocence, and the right to remain silent. These concepts are static, they are fixed. The law has not changed on these matters since we've started the process. Is the state ready to inquire?
Yes, sir.
You may.
Thank you. Hi, everybody.
I'm Sarah Catherine Dugan. I'm representing the state of Florida in this case, along with Georgia Kappelman. I know y'all are tired, hungry. It's 5 o'clock. I'm going to try to be really quick. I want to go over just a couple of concepts with our new folks to see if y'all have any strong feelings about any of them. But if any of our original folks that are here in the first and second rows, if you have anything that you want to add, change your answers on, an idea that popped into your head, just raise your hand and let me know. All right, so Ms. Kappelman talked about reasonable doubt. The state's burden in a criminal case is we have to prove the case beyond a reasonable doubt. We have to prove a crime was committed and that Mrs. Adelson is a person who committed that crime. And we talked about the definition of reasonable doubt. It's not a forced doubt, something you're making yourself believe. It's not a speculative doubt or a possible doubt. We could all sit around and come up with maybe this happened, maybe that happened. The doubt that you're having has to be reasonable. Does everybody understand? Okay. And we talked about why it's beyond a reasonable doubt, because it's impossible unless you're a witness to be convinced beyond all possible doubt of anything. Okay? Hearing that though, do any of our new people feel that I understand what the burden is, but it should be higher than beyond a reasonable doubt? I would personally have to be convinced beyond all possible doubt in order to reach a conviction in a criminal case. Does anyone feel that way? First or second row or third row? Okay. And who decides whether the doubt you're having is reasonable to believe, given all the evidence in the case? Who decides that? You guys do, right? Okay. And you do that thinking back on everything you heard in the case, using a totality of the evidence that you heard. We had a couple of people in when the defense was asking questions that some of you mentioned, Mrs. Adelson, maybe she did something to be charged, but, and while I understand what you're saying, that's not something for you to consider in a criminal trial. The law is that she's innocent until proven guilty, and that it's the state's burden to prove the charges beyond any reasonable doubt to you all through the evidence you hear from the witness stand. Does that make sense to everybody? Okay. So that's something that should not be considered. The evidence in the case and whether it meets that burden is what y'all consider, okay? And speaking of evidence, if you're picked as a juror, your job is going to be to focus on that evidence. That could be physical evidence, like a picture you can hold, or it could be testimonial evidence. That's going to be a lot of what y'all are hearing. People are going to be coming up to the witness stand that may have knowledge or information about the case, or people who investigated the case are going to be listening to the words that they say, watching their body language, so that you all can determine the facts of the case and what happened here. And then you're going to apply what you've heard to the law Judge Everett gives you and render a verdict. One thing that Ms. Kappelman touched on is that it's not the jury's job to decide the sentence. Knowing that, though, is there anybody who feels that I just would not be able to reach a verdict if I didn't know what the sentence is going to be? Anybody on the first row or second row or third row? Okay. Another thing I thought about is, obviously this is a first-degree murder case, and when you hear first-degree murder and you talk about possible sentencing, sometimes people think death penalty. That's not something that's on the table in this case, or could ever be a possible sentence here. So just want to make that clear for everyone when we're talking about that, okay? And I didn't see anyone's raised hands, so everyone is okay leaving this sentence up to the law and to Judge Everett, and you all decide the verdict, right? Okay. We talked about the principles instruction. You guys heard the law on that. Even though maybe you're not the person who pulled the trigger in the bank robbery example that Ms. Kappelman did with the court reporter, if you had the intent that trigger be pulled, if you did an act or said some word that encouraged or assisted the person who did the shooting, then you can be considered a principal and treated as if you were the person who pulled the trigger and did the shooting. Does that make sense? All right. Now, okay, so I have another example that if you are, let's say during a football game, if a quarterback throws a pass to a wide receiver, okay, the wide receiver catches it in the end zone, it's a touchdown. If scoring a touchdown is a crime, who is a principal to that touchdown? What do y'all think? Let me see. What do you think, Ms. Tolbert?
After what you just said, I'm confused. But I will say, I guess the guy catching the ball would be the one in trouble.
Wide receiver? Catch the ball to make that touchdown happen. He wants it. He's running, trying to catch it. You don't know?
Confused me.
Okay. Is he doing an act or saying a word to assist that touchdown?
The person blocking or the person throwing the ball?
The person blocking.
He's doing his position. He's doing what he's supposed to do in the game.
Okay. Okay.
It's confusing.
I gotcha. Okay, so if the person blocking is doing an act of blocking so that the touchdown can be scored, and he wants that touchdown to be scored, is he a principal? Okay. Does everybody agree with Ms. Tolbert there? Oh, she's
good evening. What I'm trying to do is go through my outline to pick out the key topics I want to address so that we're not here for another hour, hour and a half. Figured that you guys have other places you would like to be at this hour, as do we. Did everyone hear when I discussed the concept of implicit bias earlier?
Yes.
Yes? You all agree that you will make a conscious effort to be aware of that if you were selected as a juror and in your deliberations?
Yes.
Okay. By a show of hands for the new ones, anyone in a leadership position? Okay, we got quite a few. Mr. Oh, I'm sorry. Okay. Do you have staff that work with you?
Yes, I have 2 staff that work with me right now.
Okay.
That I've been operated for the last 13 years, so I've had a staff of 10 at times.
Okay. How do you, when you're a leader, try to draw out other people so that everyone is involved in a conversation?
You want to set up a process or a system to do that. You want to set up a process or system to do that. I think it's the easiest way up front to get everybody drawn in, kind of let everybody know. Let's have a system where we delegate. Everybody has a time to speak or give their thoughts, and then we can let them come back.
And so, as a leader in that type of scenario, you would make sure that everyone's voice is heard.
Yes, absolutely.
Okay. Even the ones that don't really want to speak.
Everybody has to be heard.
Everyone has to be heard.
Correct.
Okay. Ma'am, what was your number? No. Yeah, 28. Thank you. I didn't have it written down properly. You raised your hand when I asked about leadership position. How do you avoid a misunderstanding?
To clarify, I'm not hired now, but I was
Congratulations.
Thank you.
When you were working, and it would apply now too, how do you avoid misunderstandings when you're in a group setting?
Repeating what somebody said, making sure there's active listening and active communication. Going back to people and making sure that they repeat what's been said or repeat the question.
So in other words, not just listening, but comprehending. Okay. Does everyone agree with that? Yes. For those new individuals, would you agree that we're all human, we make mistakes?
Yes.
That includes law enforcement. Includes the state. Number 32, you said that your family was recently victim of a home invasion type of incident?
Yes, sir.
I'm sorry?
Yes, sir.
Is that something that, I assume that you all were home?
We were not. We were actually out of town and our cameras picked it up. So we called law enforcement as soon as we saw it and they came out and did their thing.
People arrested?
Yes.
Okay. Well, I'm glad that you guys weren't home.
Yes, me too.
Did you do anything, heightened security after that?
I mean, we already had things in place for security, so we haven't taken extra measures on top of what we already had.
Is that something that you think about on any sort of regular basis?
Sure, yeah, of course.
Now, would that or could that be something that you would think about if you were selected as a juror in this case?
No, I think they're two different situations.
Number 29. Said that your uncle was murdered.
My wife's uncle.
Your wife's uncle, I'm sorry. How long ago was that?
About 10 years.
10 years? Was that here?
In Greenville.
Greenville.
So, 30 minutes away, east.
Were you all close to him?
I guess she was because it was her uncle, but not really. He was kind of in and out as far as just maybe an odd uncle. I don't know. You know, he was there, but I don't know that he was like super close. But the whole incident was a shock. But I mean, I don't know that I never really knew him to know like if he was involved, if it was he placed himself in the situation, or whether it was just wrong place, wrong time. I don't really know the details.
So you weren't very close to him, so this isn't something that you would carry into the jury room. Okay. Number 27, I'm going to come back to you on that. You had two family members that were murdered.
Family member and a very close friend.
Okay. How long ago was that?
I thought the 17, but it's actually closer to 20 years ago.
And your friend?
6 years ago.
You still think about him?
Yes, my close friend, very much so. I was a lot younger from my aunt, but we were close. But my friend, we were actually best friends.
Sorry.
Yeah.
Obviously, my client is charged with murder, and so you could anticipate that I'd be concerned that your experience with your friend and your aunt could impact how you feel in this case. When the state asked you about that, you said, I don't think it will bleed over. You don't think that it'll influence you. I don't think is kind of equivocal.
Yeah, being candid and honest at that point, because I can't say right away that, it just absolutely won't. But I don't carry that bias into the courtroom. I weigh the evidence of the case and make a decision based on evidence.
But as you sit here, you can't say to me, Mr. Zellman, I'm not going to think about that at all.
Yeah, I'm not sure.
Okay, thank you.
I'm sorry, you said that would be not true?
Yeah.
Now, and you've heard the state say this a few times, and we probably addressed it when we were back in individual voir dire. The court's instruction is going to be that you can only rely on the evidence that's presented in court. But as you sit here, you can't tell me that I'm not going to think about that.
No, I can say that I would absolutely only rely on evidence of the case. When you're asking about thinking about the past cases of my aunt, past incidents of my aunt, our best friend, and just as a human being, as the case goes on, if I saw pictures or images or something, I may have a thought about those two.
And that actually brings up a good point, sir. This is a murder case. There are going to be pictures from the crime scene, from the medical examiner. For those new prospective jurors, are you comfortable having to see some of those pictures in this case? Is anyone uncomfortable? If I can get a show of hands. Not that we like having to do this, but is anyone uncomfortable? No hands. Thank you. I'm going to go through briefly some of the hypotheticals that I used to discuss the burden of proof. It's beyond a reasonable doubt. Did everyone hear the bank robbery hypothetical that I addressed earlier?
Yes.
Number 33. So with that hypothetical, the first one, where the witnesses to the bank robbery identify the defendant, the surveillance video depicts the defendant, and the defense attorney gets up in closing argument and says, the state didn't prove it wasn't my client's twin brother. What kind of doubt is that creating or raising? You remember what we discussed earlier? What was discussed earlier with the prior panel?
Yeah.
What kind of doubt did we discuss? Anyone else remember? Number 27.
Speculative.
And speculative doubt is not what?
Not reasonable doubt.
Has anyone ever had a knee-jerk reaction?
Yeah.
Jump to conclusions? Okay, I'm going to pick on number 30. You ever jump to a conclusion before? You realize that you were wrong? In that moment, did you say something that you may have regretted?
Yes, I did.
You realized that you were wrong.
Yes.
Everyone else have similar circumstances happen?
Yes.
Just a moment, Your Honor. Number 32, you indicated earlier that you had a family member who's retired law enforcement?
Yes, sir.
And who is that?
My husband's uncle is retired with Leon County Sheriff's Department and worked,
I'm sorry.
and also worked for the governor.
Okay. Are you close with that individual?
Yes.
Do you hold is their opinion of you important to you?
Sure, yes.
Okay. Now, would you have any concern if you were selected as a juror in this case, heard all the evidence, and returned a verdict of not guilty, how your husband's uncle would feel?
No.
Okay, thank you. Same question for number 34. No concern?
No concern.
It's your husband.
It's my husband. No concern at all.
Number 14? No, 20. Sorry, 29. Yeah, my numbers are all messed up. You have friends or family in law enforcement?
Brother-in-law works for FDLE. He's federal police. And I know he at least one is mine or retired law enforcement.
Any concern about what they would think of you if you found somebody not guilty? Even of murder?
Sure, yes, sir.
Okay. Thank you. Number 27, you had?
Yeah, it's several friends. But they several friends, they all work back in Sarasota County.
Okay.
But no concern.
You're not concerned?
No.
Okay. Anyone else have their hand or paddle raised to law enforcement? Did we talk to you about that? Well, we can't talk to you about it again, so. But specific as to the new people, sorry. Okay. As to the new people, anyone been divorced? No divorces for the new people? Good for you. I haven't been so lucky. Let's see. For the new people, as I said earlier for the prior panel, it's not something I would normally ask, and I apologize if it's offensive in any way. But just for those new people, can I see a raise of hands of anyone who has any knowledge of Judaism? There's certain events in our culture that are important in life events, correct?
Yes.
Can you give us some examples?
Referring to Judaism specifically?
Yes.
Bar mitzvahs is what comes to mind.
Bar mitzvah being
Or a bat mitzvah for girls. Yeah.
Okay, thank you. Anyone else familiar with Judaism? Number 35. How do you feel about some call them jailhouse informants or jailhouse snitches? How do you feel about them?
I can't say that I have an opinion.
You can't say you have an opinion?
I have an opinion about them.
Okay.
Or I haven't formulated an opinion.
Okay. Why do you think that somebody would, a jailhouse informant or a snitch would testify against somebody? What would motivate them?
I don't know. Maybe they want to do the right thing, or maybe they get a quid pro quo out of it. They get something.
They get something in return?
Yeah, possibly like a lighter sentence, or I don't know. Maybe they get like I don't know, more benefits.
I'm sorry?
More benefits in jail. I don't know.
So, do you judge their testimony more critically as because they're getting a benefit?
Not necessarily.
Number 28. How do you feel about that?
I don't have an opinion on it, really.
The fact that they might be getting a benefit, is that something that you would consider in weighing their credibility?
I think I'd be more cautious in listening to what they present.
Does everyone agree with what number 28 said? Be more cautious in what they say?
Yes.
Anyone in the new group disagree with that? Ma'am, do you disagree with that? Yes. No?
I would also be more cautious.
I can't hear you.
I would also be cautious.
Okay.
I'm reviewing it.
Thank you.
Good use of your paddle.
Just a moment, Your Honor. Thank you very much for your attention. Nothing further, Your Honor.
We are going to take another break. Once again, I am going to instruct you not to speak to each other. You are definitely not to discuss the case. If you need to use the restroom or stretch your legs, you may do so at this time. Please return to the courtroom as quickly as possible after you've done so. The attorneys and the court reporter can join me in the jury room. to our currently seated prospective juror panel, we have been able to select a jury at this point. I did want to extend to everyone thank you for honoring your summons and attending this process today. Although it has been time consuming, it has been very valuable in moving this matter forward, and we are not able to do our jobs without you. So with that, again, we give you our thanks. When I read the following numbers, you are to remain. Everyone else is excused at this time, and you will not need to return tomorrow or at any other point. Juror 1, you are to remain. Juror 2, you are to remain. Juror 5, you are to remain. Juror 23, you are to remain. Juror 11, you are to remain. Juror 14, you are to remain. Juror 25, you are to remain. Juror 27, you are to remain. Juror 28, you are to remain. Juror 29, you are to remain. Juror 31, you are to remain. Juror 34, you are to remain. Juror 35, you are to remain. And Juror 36, you are to remain. Everyone else is excused at this time. Have a good evening. For our remaining jurors and alternates, now the fun begins. Before you are sworn in this evening, does the state accept this jury?
Yes, Your Honor.
Does the defense accept this jury as well?
Yes, Your Honor.
Mrs. Adelson, do you accept this as the jury to try your case?
Yes.
Members of the jury, the first official act that I'm going to ask of you is to stand up, raise your right hand, and be sworn to take the oath of a juror.
Raise your right hand. Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and this defendant and render a true verdict according to the law and evidence? If so, say I will.
I will.
Thank you.
You can be seated. Before you are released for this evening, I am going to give you some instructions. At this point, you are the selected jury in this case. The instructions that you received before concerning not discussing this case, not seeking out any information about this case, or reviewing any other news or speaking to anyone about this now applies specifically to you. Does anyone have any questions concerning the court's prior instructions on what the prohibitions are concerning information in this case? Number 5.
We tell our employer how long we are expected to be here?
Yes, you may. But as far as any other discussion about the case, that is not to take place. 36.
Yes, sir. Would there be any kind of form that I could present to my employer? Because I work for the state of Florida, and they are very particular about, you know what I mean.
Do you need me to call somebody?
I may. And I left today. So you know that
There will be a form that will be provided to you from the clerk that outlines the fact that you've been selected for the jury and the length of the trial. Any other questions concerning that matter? All right. I believe earlier when we went into individual voir dire, we discussed that we would be working more or less a standard day. You are to report at 8:45 tomorrow, and we will expect to finish by around 5:30. It is important because you must move as a group for everyone to be on time. Also, as well, as ridiculous as this may sound, once you arrive, please use the bathroom before you come to the courthouse. If all 15 of you need to use the restroom, that is going to hold us up from getting started. The bailiffs are going to provide you information for parking throughout the duration of the trial. Also, as well, this is the courtroom that we will be in for the duration of the trial. It does vacillate between hot and cold. If you need to bring a jacket or light sweater so you're comfortable, please do so. You are always permitted to bring reading material with you during any breaks. However, again, you are not to discuss the case with each other, even now as selected jurors. You may discuss any other matters that are unrelated to the case during your service. You can talk about the weather. You can talk about how many wins you think FSU might get this year, but you can't talk about the case. Does anyone have a question concerning this? Yes, sir.
Sound like a kid, but what about food? Can we bring food?
You can bring food. I will also have some snacks that are back there for you. Went to Costco, bought them myself. Hopefully you like them. If you don't, you always have money and you can obtain what you need. Any other questions? There are no bad questions before you are released.
Thank you for that one.
Number two.
Is the start time at 8:45 every morning?
You are to report at 8:45. We anticipate getting started by 9.
We report downstairs?
Yes. Please report to the area where you initially reported for jury selection. You're to move there as a group. Oh, 1 second.
We're going to take them in there and discuss coming up with them.
Very well. The bailiffs will explain to you where you will meet, but again, do not come up to the courtroom by yourself. You're to move as a group. Does everyone understand this? Any other questions before we part ways for the evening? 31.
I know it sounds silly, but still business casual for this go?
I'm not going to tell you what to wear and wear something that you'll be comfortable in the courtroom with. Beyond that, I'm not going to critique your dress code. I'm not the principal at the high school. Yes, ma'am. 35.
Are we going to be in session on Labor Day? Is that the holiday now?
For Labor Day, we will not be having court. That is a recognized federal and state holiday for anyone who already has a Labor Day plan. This trial will not affect that. 29.
Just to verify, so right now we need to block out at least 2 weeks is what we're assuming. It could be shorter, could go longer, but is that a good
We're
starting
anticipating
point?
the trial ending by September 5th, but if it possibly goes longer, certainly everyone will be made aware of this, so that way you can address any issues with work or other matters. Any other questions? Very well. I will see you tomorrow, bright and early. Again, please be mindful of the instructions that you've received. We will get started with the court's instructions, the opening statements, and then we will hear from the witnesses. Have a good night. Opening. The issue can be argued now. Mr. Zellman.
We'll withdraw the objection at this time for purposes of the opening.
Very well. Do the parties have anything further to raise that we have not already addressed through the process today for jury selection or other matters?
No, Your Honor.
All right. Please report also by 8:30 tomorrow. We will wait for the jurors to arrive. You'll have the opportunity defense if you need to speak to your client before we have the jurors there. Everyone can prepare for their openings. Are there any multimedia aspects to the openings that we need to address or you have not already worked out?
We will be having a presentation that I'm familiar with how to use equipment technology.
All right. If you need to practice with that before we get started, please do, so we can move through seamlessly. We'll see you all tomorrow at 8:30.
Thank you, Your Honor.